Welcome, one and all, to the Court of Appeals Law Day celebration. My colleagues, Judges Joseph Bellicosa, George Bundy Smith, Howard Levine, Carmen Beauchamp-Saparic, Richard Wesley, Albert Rosenblatt, and I are absolutely delighted that you are here with us. We're also so pleased to welcome the Dolgeville Central High School Band. A special hand for its director, Linda Hederlein, for the elementary and junior high school band director, Chalia, and for the choir director, Bill Raymond. Thank you all so much. For some, the daffodils and the tulips signal the arrival of spring. For others, they're a sign of the return of baseball, especially, I would think, if you happen to come from Dolgeville, New York, which, as I'm sure you all know, is the home of Mark McGuire's Big Stick. For me, however, the magnificent miracles of nature that are blooming all around us herald the arrival of Law Day. That's what happens to you when you've been a lawyer and a judge for 37 years. Actually, as it turns out, my own legal career and Law Day are just about of the same vintage. Conceived by the American Bar Association some 4 decades ago, Law Day stood as America's counterpart to the Soviet Union's celebration of May Day. In contrast to Soviet displays of military might, here in America, we celebrate the enduring preeminence of the rule of law. At the Court of Appeals, we have every year come together for what is not only a serious rededication of the cornerstone of this great democracy, but also a delightful gathering of friends and colleagues who toil in and around the vineyards of justice. The American Bar Association created the celebration, and each year it also designates the theme, the idea being that in coast-to-coast conceptual unity there is strength. And this year's theme, for the 3rd straight time I might say, is Celebrate Your Freedom. As we all know, nothing underscores a message so much as its repetition, and what message is more worth trumpeting, particularly given the world situation today, than the fact of our own cherished freedom under law. Americans take pride in their shared values, their unity, but we also prize our differences, our diversity. So while across the country courts and civic groups are putting on ceremonies under the united theme, Celebrate Your Freedom, each observance also has its own individual imprint. Here at the Court of Appeals this year, we have chosen to highlight one particular freedom that plays an enormous role in maintaining all of the other liberties we enjoy, and that is freedom of the press. And so we welcome today a number of representatives of the press joining us here at Court of Appeals Hall for today's celebration. I should tell you that in preparing for today's events, I consulted James Lipton's book, An Exaltation of Larks, to see if there was a recommended term for describing an assemblage of journalists. Mr. Lipton's suggestion, a scoop of reporters. So greetings to the scoop joining us here today. In the interest of full disclosure, I have to tell you that I did look for, but unfortunately could not find, any term for a grouping of judges. But I'm sure that the wordsmiths among us will soon get to work on filling this linguistic gap. I began these remarks by noting that this is by now a distinctly middle-aged tradition celebrating Law Day, and that it has a personal resonance for me, since it parallels my own arrival in the legal profession. The presence today of members of the working press adds greatly to the feeling, because I actually arrived in the legal profession through the back door, or maybe more accurately, the side door of journalism. Some of you may know that I never aspired to make my life in the law. My ambition was to be a news reporter, a maker and shaper of world opinion, a member of what has been called that tough, hard, cynical lot filled with savage humor and the wisdom of the streets. That's not my characterization. Sadly for me, the only newspaper job I was able to secure was as a social reporter in Union City, New Jersey, and quite frankly, the best thing about that job was getting off the bus every morning for work in the shadow of the burlesque theater. So having failed with the Fourth Estate, I had to bring my savage humor and street wisdom here to the Court of Appeals of the state of New York. Mine was a failed ambition, to be sure, but as you can see, things haven't turned out all that badly in my fallback profession. In retrospect, I see a connection in my own personal career path because throughout this nation's history, the law and the press have been closely linked to one another. Every New York schoolchild learns the story of John Peter Zenger, the courageous immigrant printer imprisoned for seditious libel for his criticism of the royal governor of colonial New York. After his original lawyers had been disbarred for their efforts on Zenger's behalf, attorney Andrew Hamilton dramatically rose from among the spectators to present Zenger's case. He exhorted the jury to return a verdict of not guilty in the name of liberty, in his words, to expose and oppose arbitrary power by speaking and writing the truth. According to one source, an outburst of huzzas greeted Zenger's acquittal 10 minutes later, and a night of celebration followed. The Zenger trial is, of course, hailed as an early landmark of freedom of the press in this country, and I, for one, especially appreciate Printer Zenger and the jury's vindication of his efforts. After all, the abuse of power that his paper had criticized was the dismissal of New York's Chief Justice for ruling against the governor. The courts of this country have played a key role in the years since the Zenger case in ensuring that the press's liberty to expose and oppose was protected from assaults from a variety of quarters. The courts have reversed libel suits that sought to silence descriptions of civil rights abuses in the South in the middle of this century. They have disallowed government restraints on the publication of information about America's involvement in the Vietnam War. The reason that courts have been protective of freedom of the press, the reason that the Constitution protects the freedom of the press in the first place, is that the press plays a central role in assuring that our national experiment in self-rule actually does work. Government by the people requires information and analysis. It requires argument and counter-argument. It requires education and debate. It requires conversation. As Judge Leonard Hand observed, our Constitution presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. The courts enable the press to do its job by enforcing basic protections, and the press, in turn, helps the courts to do their job by increasing public awareness of what we do and why we do it. There is no question but that the courts today are an important beat because the public wants to know about the functioning of their justice system. Whether it's the trial of the century or the appeal of the minute, the press can demystify the legal process and provide real-life examples of grand constitutional theories in actual action. There was a time in our justice system that courts really didn't want to be demystified. They functioned in relative obscurity, using phrases from languages long dead, relying on a seemingly bottomless supply of public respect for government officials who were garbed in black robes and wielded small wooden mallets called gavels. Clearly, those days, for better or worse, have gone the way of rotary telephones and carbon paper, courts today are definitely a part of the national conversation. The challenge for both the courts and the press is to assure that the conversation remains civil and informed. The press can help by having coverage that is balanced and complete. Judges don't write on a blank slate when they resolve disputes. A legal decision is more than just its result. It is reasoning based on the law. And the public deserves to know and understand the legal background so the public can determine for itself whether the judge's call was a reasonable one. For their part, courts, and lawyers too, can help raise the level of the conversation by making more of an effort to reach out to the public, to explain the basic principles, to get the word out that the American system of justice, for all of its shortcomings, is still the best in the world. Judges are not free to discuss pending litigation, but there are lots of other things we can talk about in schools, in public forums, in op-ed pieces, with reporters. At the beginning of these remarks, I said that the fact of our freedom under law was a point especially worth celebrating, given today's world situation. That's true with respect to the general level of freedom we enjoy. It's also true with particular regard to the freedom of the press, a lesson underscored as we follow the unspeakable horrors in Kosovo. It should surprise no one that hand in glove with the policies of repression and ethnic cleansing are severe restrictions on the press. Tyranny has no toleration for open government, uncensored debate, or a free press, but democracies demand them. The give and take of public discussion is not always pleasant. Sometimes it's downright painful, but ultimately it is that tension, that discomfort, that keeps our government honest and free. A free and robust press, a vibrant and independent judiciary, two rock-solid cornerstones of American liberty, two rock-solid institutions we deservedly celebrate on Law Day 1999. And now I would like to introduce Lieutenant Governor Judge Mary O'Donoghue.
Thank you, Judge Gay. I'm very happy that you included Judge in that introduction. It is truly an honor. Thank you, first of all, for inviting me to speak with everyone this afternoon. It is an honor to join you as Chief Judge of the Court of Appeals, your esteemed colleagues in the Court of Appeals, Attorney General Spitzer, and all those assembled here today as we commemorate Law Day and its theme, Celebrate Your Freedom. As I reflected on the theme, ladies and gentlemen, for today's Law Day, I took great pride in the fact that as New Yorkers and as Americans, we enjoy freedoms that are unequaled anywhere else in the world. In order to fully appreciate the breadth and depth of these freedoms, we need only focus on the ongoing conflict in Kosovo, where people are literally fighting for their lives to enjoy the freedoms that we all too often take for granted. One of the most basic freedoms that we cherish is the freedom from fear. Freedom to raise our children in a world in which their safety and the safety of American citizens is secure. In New York State, we have enjoyed a dramatic reduction in the crime rate. Thanks to the hard work of law enforcement throughout the state, our crime rate today is at a level which has not been witnessed since the 1960s. Our crime decline is twice that of the national average. Our communities have been made safe, and the quality of life in our neighborhoods has flourished. Despite these successes, as we are all acutely and painfully aware, recent events in the small town of Littleton, Colorado, have shaken our sense of security at its very core and threatens our freedom from fear. The shocking scenes that we all witnessed during the terrible tragedy at Columbine High School will be forever etched in our minds and in the minds, most importantly, of our children. Over the last 3 years, there have been close to 20 similar tragedies occurring in our schools throughout our nation. Children killing children. A horrible thought, but unfortunately an occurrence that has become all too common in our world and a reality for our children. Earlier this week, I came across an online survey taken of more than 4,000 teenagers nationwide, in which they were asked, could one of your classmates be a killer? Shockingly, 47% of the respondents answered yes, and another 38% answered maybe. A mere 14% answered the question in the negative. All of the parents and grandparents here today undoubtedly have reflected on the horrific events in Colorado last week and have shared my concern for our children and for the world in which our children are growing up. A world far different from the one we knew as children. I can say unequivocally that I never was afraid to go to school, except for the 1 or 2 times I didn't have my homework done. But even then, I never feared for my safety. It was never a concern. It was never an issue. But today, imagine the fear a child could carry to school after seeing the pictures of Columbine High. We can philosophize, we can talk, we can list a litany of possible causes for these tragedies. They range from violence on television and in the movies, to the internet, to video games, to the decline in the family structure. In reading commentaries on the killings in Colorado, I was particularly struck by an editorial which made the point that a tempting response to this tragedy would be to put restrictions on our children's interaction with the outside world. But as that editorial went on to conclude, it is not what you keep your children from that will save them. It is not what town you move them to. It is what you put into them in the first place. Whatever the causes may be for the rash of violence in our nation's schools, it is something which we as a society cannot ignore. Early this week, Governor Pataki outlined a series of legislative and programmatic initiatives to address this problem. As many of you know, the governor has also appointed me chair of a task force to develop additional strategies to combat school violence. As professionals, each of us, in some way in the legal system, we too have a role, each of us, in tackling this perplexing problem. We have a responsibility to do everything possible to identify troubled youth whom we encounter, to take whatever steps necessary to reach out to those youth, and where appropriate, to link those youth to counseling services, for their sake as well as the sake of our society. As a former district attorney, as a state Supreme Court justice, and as a teacher, I often came into contact with teenagers who displayed, to some extent, troubled behavior. Many of the youth brought into our family and criminal courts today for delinquent behavior exhibit very few signs of remorse or guilt. And many times their parents, if they come to court at all, display the same behavior as their children. The tragic causes of child abuse and neglect with which we have become all too familiar and accustomed present serious challenges and problems for each of us. It is in those cases that our judges, our prosecutors, our defense lawyers, our law guardians, our probation officers, and our court personnel need to be vigilant in reaching out to the youth and ensuring that their problems are addressed. The justice system does not operate in a vacuum, but rather is an integral part of the very fabric of our society. We are sworn to uphold the law and protect our cherished freedoms. And to that end, we all owe a responsibility to our children to do everything humanly possible to make their world a safe place to live. A place free from fear, and where they can enjoy the freedom from fear. A place where they can grow and develop into not only productive members, but productive leaders who want to be leaders in our society. Our duty in this area goes well beyond our obligations as participants in the judicial system. Our work and our obligation extends further than the proper application of the law and the responsible exercise of governmental authority. We apply the lessons of our training and our education, yes, but it is as people, not just as professionals, that we must seek these solutions and must find the answers to ensure that our children will enjoy the sense of safety, the sense of security, the sense of freedom that we have enjoyed. Reflecting on the past week, ladies and gentlemen, I was shaken to my very bones. Reflecting on the past week, I thought of my 11-year-old son. It's his everyday world that I am endeavoring to protect now. We need more than the sum of our knowledge. We need all of our experience, all of our sensitivity, and every ounce, and by far not the least important of these qualities, every ounce of our common sense that we can possess to address the problems that led to Littleton and to see that those problems are resolved. It must be our goal as American people, as well as professionals, that decades from now, as our children, hopefully, will assemble here in this magnificent setting, outside this magnificent chamber, that they will know and celebrate the freedom that we celebrate today. On this, the last law day of the greatest century freedom has ever known, let this be our pledge and our promise to the future. Thank you.
Thank you so much, Lieutenant Governor Donahue, for that important and stirring message. I would next like to call upon, for his remarks, the Attorney General of the State of New York, Eliot Spitzer.
Thank you, Judge Kaye, members of the court. It is great to be here, and good morning to everyone. This is the third successive year that Celebrate Your Freedom is the stated subject of the entire nation's Law Day. This reflects either an excessive deference to precedent, a not surprising lack of creativity on the part of lawyers, or perhaps the underlying importance of these words. I choose to believe it is the last reason stated. We as Americans have always taken great pride in our country serving as the exemplar of the rule of law. After all, it is the rule of law that is the bulwark that protects and permits the freedoms we cherish to remain vibrant. The rule of law survives only when the public has an underlying respect for the law and an uncompromising belief that the law is enforced and justice dispensed with absolute fairness. We all must do more to ensure not only that this is the case, but also that the public understands this to be the case. Too many people do not believe our laws are an instrument of fairness for everyone. The most potent way to ensure respect for our laws and legal opinions is to provide our citizens with a better understanding of the judicial process and the reasoning, not just the results, that underlie the judicial opinions that are the central protection of the freedoms we celebrate. To build the necessary appreciation for our legal process, we, government, community, and religious leaders, must do a better job encouraging everyone to be a part of that process, whether by serving on jury duty or through viewing press coverage of a trial process. Our founders understood that jury service would safeguard the highest level of justice our system could provide and give each person a degree of ownership of our awe-inspiring legal system. By shouldering the responsibility and exercising the power of such an important function within the legal process, we learn the central lesson of democracy, that the system requires active participation, not passive obedience. Thank you. As everyone here knows, Chief Judge Kaye has made revolutionary changes in jury duty, from expanding access to improving the conditions of service to treating jurors with respect. These steps have allowed many more people to become stakeholders in the judicial process and thereby understand and appreciate the role that the courts play in our lives. Another way to give the public access is through cameras in the courtroom. I realize I have one fan. This is great. It's not my mom. I realize that some critics point to celebrated trials, such as the O.J. Simpson case, as exhibiting the American legal system at its worst, and highlight that experience as a basis for opposing televising trials. I would argue that the remedy for bad speech is better speech, not suppression. In truth, the American legal system has a glorious past, an impressive present, and a grand future. We must build respect among the public for our trial process by showcasing it and by making it more fully available for public scrutiny. There are many provisions for appropriate exclusions from coverage that can be made when the situation so warrants. In many state experiments with televised trial coverage, appropriate exclusions are being made to protect victims and to maintain the integrity and fairness of the trial for all. The popularity of fictional lawyering shows such as LA Law or The Practice suggests that the public has a deep and abiding interest in the judicial process, which transcends the merely dramatic. Our rule of law still finds resonance in the hearts and minds of Americans, and we should give them as much exposure to the legal process as we can provide, including through jury service, televised trials, and enhanced public educational efforts. If we have confidence in the integrity of our public institutions and the fairness of our legal process, we command loyalty as our people understand them better and realize that justice is applied equally to us all. All of these steps will help restore faith in the judicial decision-making process. But there is one more step that we must take, which is to restore faith in the reasoning of judicial decisions themselves. Many individuals who help shape public opinion, including elected officials, community leaders, and the press, have not served the public well in the manner in which they have treated judicial decisions. That is because our reactions almost always focus on the result that is reached rather than on the reasoning behind that result. We all know that whenever a court suppresses evidence or does not admit into evidence the fact of a prior criminal record, criticism of the result is easy. Public opinion makers are often too quick to condemn that result. Instead of deriding the result, we should instead examine the reasoning and ask whether the reasoning might not be critical to protecting the freedoms that we all accept as essential, the freedoms we celebrate in our Bill of Rights. We must explain that the Fourth Amendment, which resulted in the suppression, is the same Fourth Amendment that keeps us all safe from unwarranted government intrusion in our own homes, and that excluding evidence of prior criminal conduct is perhaps essential, not just to the presumption of innocence for this defendant, but for all of us. If we criticize judges when they uphold the constitutional freedoms of others, then we erode those protections for ourselves. Eventually, not only will we lose the faith of the public, but we will lose the rule of law upon which all of our freedoms are based. So today, I ask everyone here to join me in taking steps to rebuild the public's respect for our judicial system as a whole, through increased education, access, and public participation in the process, and most importantly, by ensuring that our own actions show that same respect that we ask of others. Thank you very much.
Thank you. Thank you, Attorney General Spitzer. I might say on behalf of the many judges who are here, administrative judges, supervising judges, Court of Appeals judges, the fabulous 3rd Department Appellate Division, on behalf of all of the judges, Attorney General Spitzer, we say affirmed. And I unanimously affirmed, and I might say, I just got my second jury notice in the mail. I'd next like to call upon our State Bar President, President of the New York State Bar Association, Jim Moore.
Judge Kaye, members of the Court of Appeals, Lieutenant Governor Donahue, Attorney General Spitzer, my family, my friends and colleagues. We gather today at this particular Hall of Justice not to celebrate or honor an individual or a particular achievement or some particular event, but rather to celebrate a hallowed custom of our people. That is the commitment that all of us have made to govern our lives and our relationships with laws crafted by our representatives. Now, that's not a commitment that is unique to our society. It's been done before. But it is one of the fundamentals, one of the basics that has kept us constant and always renewing as a society. One observer wrote several years ago, "We citizens must have a habit of obedience to law. For if we do not, this intricate and delicate machinery in which we live will very quickly come to a stop." I think it therefore fitting that we take some time today to honor this tradition of law that surrounds us, and to remember, as others have already noted, that beyond our shores there are millions of people who yearn for the social order and the freedoms of our society. In fact, the alternatives to the rule of law are quite stark and unappealing. In my relatively short life, I have observed at close quarters the corrosive and dispiriting effect upon the people that a totalitarian government in the Soviet Union brought about. Later on, I saw the physically and mentally numbing consequences of life in a country where there was no law when I served in the Army in Vietnam. And as with many of you today, we watch the horrific consequences of lawlessness on our own televisions in our homes when we see the tragedy in the Balkans unfolding. I think we need days like this to reflect upon our nation's history and the healing and binding role that law has played in it. When our forebearers, people like New Yorkers John Jay and Alexander Hamilton, crafted our form of government, they imagined a government that would be based upon laws of the people and not those dictated by some individual or some group of zealots. The people were relatively quick to endorse that commitment and the vision of our forebearers, but very quickly they found that living with the rule of law would not always be an easy task. The bonds of their commitment were sorely strained during the Civil War, during the dark days of Reconstruction which followed, during the Red Scare of the 1920s, during the Depression, and more recently, even in our times, during Watergate and during the Vietnam eras. But quite remarkably, through it all, whenever that specter of radical change or the personal aggrandizement of power appeared, the commitment of the people to a government of laws reasserted itself, and orderly change resumed. We also need days like this to remind ourselves that this gem that we hold in our hands, a law-based society, has come to us at a steep price. Portions of that price were paid in blood on battlefields like that at Saratoga and at Gettysburg. Others paid parts of that price when they surrendered their personal dignity and their personal freedoms, when they marched with people like Susan B. Anthony for women's suffrage, and when a few, and I mean a very few, publicly stood up with Joseph Welch to challenge the demagoguery of Joseph McCarthy, and when others joined with Martin Luther King Jr. and some to die for the civil rights of all Americans. We also need to remember that our national commitment to the rule of law has continuously been reinforced by lawyers practicing in our courtrooms and by our judges. It was in a courtroom that John Marshall said that no law, no matter how popular, could escape judicial review for constitutional soundness. And it was in a courtroom that the outlandish notion that two groups of people could be separated but would nevertheless still be considered equal was firmly cast aside. And it has been in our courtrooms that judges have periodically reminded us that everyone, presidents, executives, and even lawyers, must abide by a common standard. The abundance of the freedoms that we enjoy in this law-based society of ours is truly a breathtaking spectacle. Whether it is the right that we have to express ourselves freely even when the majority doesn't agree with us, or the relative ease with which we can gain access to our courts to resolve disputes, it is difficult to imagine a group of people who have ever enjoyed greater freedoms than do this generation of Americans. There is, however, a danger that lurks beneath the surface of these good and plentiful times. That is the risk that we will grow complacent, that we will forget the abundance of our privileges and the prices paid for them, and that we will fail to nurture and protect this vital component of our society, the rule of law. I think, however, we can avoid that danger if we recognize that we too must sacrifice and pay some price for the privileges that we enjoy in this society. Now, I suspect that the price that we will have to pay will never be as steep as that paid by our ancestors. Nevertheless, I think that there are three responsibilities to which we must constantly attend. The first and the easiest is this: we must regularly conduct ceremonies like this one, and the one that took place at the county courthouse earlier this morning, and ones that are taking place in courthouses all around this country, to remind ourselves of the heritage that we honor today and the sacrifices that have been made by other people so that we can enjoy these abundant freedoms. Second, we must commit to using our freedoms responsibly. We must acknowledge that for every privilege, there is a limit. For every freedom, a responsibility. For every liberty, a point at which its exercise becomes a vice. We must occasionally remind ourselves of what Judge Barrett Prettyman once said: there is no liberty without order, and there is no order without systematized restraint. And my good friends, we must always bear in mind that a community composed of individuals doing nothing more than exercising their freedoms is hardly a community. Third and finally, we must be certain that the justice system we celebrate today is accessible to all of the members of our society. During this past year, it's been my great privilege to visit literally dozens of legal aid and legal service offices around this state and in other parts of the country. During those visits, I have seen with my own eyes the difficulties which face many of our poorer and even some of our middle-class citizens as they try to find a lawyer to represent them, or to see a judge, or to gain access to our courts. I have seen those folks grow skeptical of and cynical about our society's promise of fairness and equal treatment under the law. I have seen some of those folks come to the point where they would wonder why any group of people would come together on a day like this and celebrate our freedoms. We lawyers and judges are elected officials in the government our community leaders. We cannot turn our collective backs on our fellow citizens simply because they lack the financial resources to be treated fairly and equally by our justice system. For us, a large part of the price that we must pay today and tomorrow is to make the financial and personal sacrifices necessary to assure that everyone in our society has access to justice. James Madison once said that in the history of mankind, the freedoms of the people were more frequently lost by gradual and silent encroachment than by violent and sudden usurpations. Today, 211 years after Madison spoke those words, his counsel should sound clearly in all of our ears. Let us therefore resolve on this law day of 1999 that all of those freedoms that we enjoy will never be dissipated through inattention, through lack of appreciation, or unwillingness to continue to sacrifice for them. Rather, let us recommit, let every one of us recommit today to assuring that our freedoms will be available to everyone in our society, and that we will cherish each and every one of those freedoms even as we would a child. Thank you.
Thank you, Mr. Moore. Jim, an absolutely outstanding State Bar President, and thank you for those thoughtful remarks. And now I'd like to call upon our Chief Administrative Judge, Jonathan Littman, for the presentation of the Merit Performance Awards.
Thank you, Judge Kaye. On this Law Day 1999, it is my privilege to honor 6 individuals whose quiet dedication and pursuit of excellence have enhanced the quality of our judicial system. On behalf of today's guests of honor and the 15,000 judges and non-judicial men and women of the unified court system who work so tirelessly to earn the public's trust and confidence, I want to thank Chief Judge Kaye, the Associate Judges of the Court of Appeals, and Attorney General Spitzer for once again making this awards presentation an important part of these Law Day ceremonies. I would ask each award recipient to please step forward when their name is called. The 1999 Merit Performance Award for an act of heroism, Anthony P. Jimenez, Chris Lemondola, Bernard Levy, Senior Court Officers, Nassau County Supreme Court. On the morning of December 8, 1998, as jurors in the Nassau County Supreme Court were quietly going about their civic duty, a male juror suddenly collapsed in their midst from a severe heart attack and stopped breathing. The stricken juror was truly fortunate that Senior Court Officers Anthony Jimenez, Chris Lemondola, and Bernard Levy were all on duty that day. The officers rushed to the scene, quickly administered CPR, and attached an automated external defibrillator to the man's chest, which emitted a life-saving electric shock that jolted the man's heart back into a normal rhythm. Breathing once again, the juror was transported to the hospital. It was thanks to the careful research and urgent lobbying of Senior Officers Jimenez, Lemondola, and Levy that the court had recently obtained the AED device. Nor did the officers stop there. they took it upon themselves to get the training and certification required to operate the AED equipment. The value of their foresight and training was dramatically demonstrated last December, paving the way for other court locations around the state to acquire AEDs. For their grace under pressure and exceptional teamwork, we are pleased to honor Senior Court Officers Anthony P. Jimenez, Chris Lemondola, and Bernard Levy with 1999 Merit Performance Awards. Yeah, I think so. $1999 Merit Performance Award for Outstanding Performance in the Workplace, Anna Y. Rumberg, Esquire, Associate Court Attorney, New York County Supreme Court. Anna, please come forward. Associate Court Attorney Anna Rumberg is universally admired for her total commitment to her profession and her colleagues. Working in the high-volume New York County Supreme Court, which handles many of the state's most complex legal disputes, Anna's command of the law and excellent writing skills are highly sought after by the justices of that court. Her ability to quickly analyze complex legal problems and her calm demeanor, even under great time restraint, have made her a specialist in handling emergency or expedited legal proceedings. Above and beyond being an outstanding attorney, it is Anna's warm, sincere personality that makes her a treasured presence in and around the courthouse at 60 Center Street in New York County. Among her many projects, Anna has helped to organize the Holocaust Remembrance Program, the Martin Luther King Memorial Program, and the Take Our Daughters to Work Day program. These activities have brought members of the public and the courts together and promoted shared understanding among individuals from all walks of life. In her spare time, Anna also serves as a volunteer in the Office of the Self-Represented and is involved in many charitable activities, such as raising money for Alzheimer's research. For her superb skills as an attorney and her exemplary positive attitude and willingness to help others, we bestow upon Anna Y. Rumberg a 1999 Merit Performance Award. $1999 Merit Performance Award for Outstanding Performance in the Workplace, Tamara C. Kirsch, Senior Court Clerk, New York County Family Court. Tamara Kirsch is a gifted problem solver whose outstanding organizational skills enable her to perform multiple duties in one of the busiest courts in New York State. Tamara was assigned to the new Family Treatment Court in Manhattan in March 1998. This innovative court handles neglect and abuse cases involving substance-abusing parents, providing parents with access to the treatment and services necessary to keep their families intact. Tamara is responsible for much of the court's organizational infrastructure, from developing specialized orders to a separate filing system to mastering every courtroom procedure. Whatever the challenge, Tamara enthusiastically tackled and conquered it, often staying late or arriving early to do so. Tamara's next assignment was to assist in establishing a new model court to serve as a prototype for handling child neglect cases. The model court is designed to move children out of foster care quickly through close judicial oversight of every aspect of the case. Tamara's involvement has been integral to the model court's success and has earned her a well-deserved promotion. In addition to her many other duties, Tamara trains new employees and is responsible for resolving court-wide computer system problems. An all-around outstanding and dynamic individual, Tamara epitomizes what it is to be an expert at her craft. For her caring, her creativity, and her work ethic, we commend Tamara Kirsch and honor her with a 1999 Merit Performance Award. $1999 Merit Performance Award for Community Service. Jawad Abdur Rashid, Hearing Examiner, Oneida County Family Court. When Jawad Abdur Rashid leaves work, his day is far from over. Involved in a myriad of community activities, Jawad has devoted his life to improving the lives of the young men and women in his community. Shortly after arriving in Oneida County, Jawad founded the Adirondack Spirit Basketball Club of Central New York, a program that each year helps over 150 young men reach their full potential by staying in school, improving their grades, and getting into college, often through academic or athletic scholarships. Jawad is personally familiar with the benefits of working with youth. A graduate of the nationally recognized A Better Chance program, which targets academically gifted teenagers from impoverished backgrounds, Jawad is now on the board of directors for the ABC program in his community. He is also on the board of directors for the Boy Scouts of the land of the Oneidas and recently took his troop on their first ever scouting trip, personally providing them with tents and sleeping bags. A recipient of many awards for community service, Jawad also devotes his time to the YMCA and the Boys and Girls Club in the city of Utica, to a local teen center, and as coach of the Clinton Central School basketball team. We applaud Coach Jawad Abdur Rashid for his tireless and positive efforts to improve his neighborhood's youth, for his dedication to kids, his giving nature, and unselfish motives. We present Jawad Abdur Rashid with a 1999 Merit Performance Award.
Thank you.
Thank you, Judge Lippman. Actually, we've been searching for a kind of massive merit performance award for Chief Administrative Judge Lippman. Isn't he phenomenal? And I certainly do congratulate today's honorees. They are the strength of the unified court system. This brings our Law Day ceremony to a close. I want again to express special thanks to the Dollettville Central High School Band for their performance today. I've been watching the clock. We promised them they would be out by 1 p.m. They are so eager to get back to school. In fact, as you might imagine, we would have had more merit performance awards, but I definitely wanted to make good on my promise to them. I thank, on behalf of all of you, today's speakers for their very inspiring and thoughtful messages, which we will carry forward with us today and on into the year until Law Day 2000. I thank all of the family of the Court of Appeals, many of whom I see before me. I thank especially my colleagues for a life that is extraordinary and marvelous beyond belief. They are really such great judges. I want to applaud them. I've got the microphone. And last but most important, I thank all of you for being here today. Happy Law Day.